Glad to have with us once again the Attorney General for the state of Louisiana, Mr. Jeff Landry. Hey, Mr. Jeff, welcome back to KEEL. How are you this morning?
Well, good morning, Robert. Good morning, Erin.
Morning.
Okay, last week a rather monumental decision by the United States Supreme Court. The deciding vote was Chief Justice John Roberts. We'll get back to that. If anybody didn't hear, you're the lawyer among the group this morning, at least for now. Erin's thinking of going back to school. You're the lawyer with us. Explain to everybody what the Supreme Court ruled and how it affects Louisiana.
Okay, well, just to put it in perspective, it was not a particular ruling on a case. Last week, what the Supreme Court did was basically suspend the enforcement of Louisiana's admitting privileges law until such time as the court decides to rule on it or whether they want to review the particular case. And so really and truly, the Fifth Circuit upheld the admitting privileges case. The Supreme Court says you can't enforce it until we have an opportunity to decide whether or not we believe it is constitutional or not.
And that law was to go into effect last week, so they just put it on hold for now.
That's correct. They just kind of put it on pause. And, of course, there's been much to do about the fact that Judge Roberts joined in the majority in staying or suspending the rule. I wouldn't read a whole lot into that because there was a similar case that the Supreme Court took up a few years ago, an admitting privileges case in Texas. The law was much more onerous or much more stringent than Texas's, and Judge Roberts in that case dissented. He believed that the law should be held constitutional. So I believe that maybe he wants to take a second bite at the apple.
The Justice Kavanaugh published a dissent. They wanted to deny the stay and let the law go into effect. What would that have done in Louisiana?
Well, that of course there was a 45-day transitional period under which rules would have been promulgated, information would have been disseminated to those abortion clinics left in the particular state, to those doctors who are operating in those clinics, as to how they would go about getting admitting privileges. But Erin, I think the bigger picture that we're all missing is that there's a double standard being created in this country when it comes to women's health care. And that is, if you go into any to see your doctor and he administers a procedure under which he puts you under some type of local anesthesia, any other procedure in the state of Louisiana that you go to, that doctor is required to have admitting privileges. You take your child to go get their adenoids taken out or their tonsils or tubes put in their ear. That doctor is required to have admitting privileges. Just in the case of abortions, are we creating a double standard? And in my opinion, it's a dangerous standard. And so all Louisiana did was say, listen, irrespective of the procedure that you're performing in a clinic or in an office, you must have admitting privileges.
You know, Mr. Jeff, abortion, especially late-term abortion, has been in the news a ton the last couple of weeks. Is this in any way, because everything seems to be representative of the ongoing battle, is this Louisiana case, is it sort of a tip of the iceberg for a bigger fight coming down the line?
I mean, it seems to be, it may be setting up for determination. Look, at the end of the day, this is murder, right? There's a living person inside of that woman. And then of course, as that child grows, okay, if you go into New York, they literally want to create a law that allows for murder. In Louisiana, that would be infanticide.
Jeff, people may not know this, but I believe there are only 3 abortion clinics left operating in Louisiana. The only one currently with a doctor with admitting privileges is right here in Shreveport. The Hope Medical Group is the only one currently with a doctor with admitting privileges at a local hospital. That would make Shreveport the capital of all abortions across Louisiana, correct?
Well, I wouldn't say that. We don't know whether or not the doctors in the other clinics could obtain admitting privileges. The important part is that hospitals scrutinize the doctors and the licenses that they have and the certifications that they have in order to provide the procedures that they're wanting the admitting privileges for. Again, what we want, Erin, at the end of the day, is a consistent healthcare law that takes into consideration the health of the women and the procedure that's going on at that time.
Mr. Jeff, this is a little bit bigger picture. It seems to me that as soon as Louisiana passed the bill requiring admitting privileges for abortion performing physicians, that the pro-choice group was right there. We're going to get an injunction. We're going to sue right away. And yet you see the outright infanticide bill that was recently passed and signed in New York State. And there's nobody on the pro-life side doing that sort of same thing, challenging those laws. Why is that?
Well, again, because of Roe. Ultimately, the 1972 decision in Roe versus Wade basically set that up. I believe, I just tell you, this is just my personal legal analysis of the law, that these issues are within the policing powers of the state. And so, New York, in my opinion, has the ability underneath Roe to pass that particular law. Again, it should be a state-by-state decision.
We're talking to Jeff Landry. One more question. If the law goes into effect in Louisiana, you're saying that those clinics will have 45 days to have a doctor with admitting privileges, or you will order them closed?
Well, I won't order them closed. The Louisiana Department of Health should order them closed. And not that the clinic would be closed, but that they would not be able to perform the particular procedures under which the doctor would not have admitting privileges.
And what's your call on that? What do you think is going to happen and how long?
Look, I think that the court has gave a great indication that they're going to take this up, and we could be in front of the Supreme Court as early as the fall arguing this particular case. I think it could be a seminal case. It could be a great case to finally put to bed the question in regards to abortion. And again, look, from a moral perspective, I believe it's wrong. I think that from a constitutional perspective, that abortion, that these are cases under which it should be a state-by-state issue.